pumped storage and loading facilities with auxiliary pipelines located at the Harbour Arterial Road, Richards Bay, KwaZulu-Natal Province. And we'll go through some of these matters, and then we'll also deal with the biannual report on transitioning of the efficiency adjustment factor and volume rules element of the tariff methodology for petroleum storage and loading facility, amongst others. We then will search forward with that understanding. Any interest to declare, members and management? I would just like to urge you to please send your field declaration of interest form to Madam Maswanganye, our committee secretary, just indicating your interest, if any. I would then like to give the opportunity to Madam Boko to then assist us throughout in terms of presenting the submissions for this meeting. As I would request Madam Boko, you would just not take more than 2 minutes for each of these, save for matters that were supposed to be workshopped prior to this meeting, just to expand a bit on them, so that you can be able to accommodate the fact that they could not be workshopped. But otherwise, stick to the 2 minutes rule throughout, because we take all these matters as read. With that, I would then like to give you the opportunity then to assist us in terms of item 5, which is the Bidvest Terminals application. Over to you, ma'am, and your team.
Thank you, Chair. Madam BJ is ready to introduce this submission, taking it as read. Over to you, Madam BJ, through your Chair.
Thank you, Ms. Boko. Thank you, Chairperson, and good morning, colleagues. LNG Storage Trading as BTT has applied for the amendment of its license issued to operate a petroleum storage and loading facilities with auxiliary pipelines located in Richards Bay, KwaZulu-Natal Province. In its application, BTT seeks to remove a cryogenic tank known as Tank PR1 and its associated pipeline from its operation license, as the tank no longer stores LPG, but currently stores butane. However, it is NESO's view that butane can be stored by BTT for its customers to then blend with propane for marketing as LPG, or be used as is for purposes of which a petroleum fuel may be used. Butane may even be used instead of LPG. Therefore, it does fall under the definition of petroleum products as defined in the Petroleum Pipelines Act. As such, it is our view that there is no need for this amendment, as the tank is currently storing butane, further substantiating facts on why butane is a petroleum product and fuel provided in paragraphs 12 to 23 of the RFD, of the decision and RFD document. It is therefore recommended on page 7 of 13 of the submission that the PPS considers and recommend to the ERs to not approve BTT's application for the amendment of its license conditions in removing the butane storage tank. Also for the PPS to approve to recommend to the ER to approve the decision and reason for decision document attached here to as Annex 1. Thank you.
Thank you very much, Madam Mabija. Members, if you've got any questions, comments, or guidance in regard to this submission, may you please raise your hands. Oh, I see Advocate Stolle's hand as well as Mr. Sibanda. Over to you, Advocate Stolle.
Thank you, Chairperson. Good morning, and good morning to members and support staff. Chair, I just have one question of clarity, which is whether does the PPA require a licensee to come to NESA if it changes the product that it is storing within its licensed storage facility or not? And I think the response to this question may really also assist in the question that I would then ask if the response is given to say no, to say that is there a need for the submission to be before us? But let me just allow the colleagues to just give me that particular clarity as to whether the PPA or any of our regulations or rules require a licensee to come to NESA when they have to change the product that they are storing within a licensed storage facility. Thank you, Chair.
Thank you, Advocate Stole. Mr. Sibanda, over to you, sir.
Thank you, Chair, and good morning, colleagues. Chair, I'm generally fine with the recommendation as well as the analysis done. So I think for me, the question really centers on both the legal and technical considerations of what butane is, and whether it is a petroleum product as defined in the Act, but also chemically whether it is indeed does constitute or is part of LPG. So I think from that perspective, I'm okay. What I'm missing though is whether we do have similar facilities that have been licensed to store butane only in our experience, so that at least we have some precedent to also back up the reasoning and the argument that we are providing. If we do have similarly licensed facilities, I think that would help. Otherwise, I think then I'm okay with the argument. Chair, the only concern that I have is with respect to paragraph 24, where we seem to offer sort of a commercial or economic argument that says this particular facility should remain licensed purely on commercial reasons, and I sort of like doubt whether we should be making that argument, Chair. That we have about 80% of local demand that is being met via imports, and that as a result, this facility is important and should remain licensed. I don't know whether we should be making that argument, but both from a legal and technical perspectives, I think I'm okay. Can argue it in that fashion, but from a commercial perspective, I doubt whether we should be advancing that argument that we are doing in paragraph 24. Chair. Thank you.
Thank you very much, Mr. Sibanda. Over to you, Madam Mbogo and your team. Your responses, please.
Good morning, Chair and members. I will go, and if the team can then add if they need to. In terms of Advocate Sitoli's question, the license conditions, there is the explicit license condition that says they need to report or inform NASRA of significant changes to the licensed activity. However, we have seen that the interpretation of that has been I'm not saying problematic, but there's different views. But it's definitely a condition of the license, and they then report as part of the monthly volume reporting. The licensees are then also obliged in terms of the regulations to submit those reports, and then in that report they must indicate in the template the type of product they are storing. So it will say then LPG, or it may say propane in some case, which I'll discuss now and that. So in short, yes, Madam, it is a requirement they did come back to NERSA, and then that was the guidance that we gave them. But then subsequent to lodging the application, they did raise the definition, which they argued wasn't explicit on that. But then Mr. Sibanda's question, the only other case we have, noting that like in paragraph 24, which we'll discuss now, there are only 3 means to get product into South Africa in terms of licensed facilities at that level, except if it comes via Mozambique and then via rail or truck to the inland, which does happen. So the only case we have, members, is Sunrise Energy, where when the construction license was done, it was explicitly added in the conditions, including the components, and we list the components. And then in terms of the operation license for Sunrise, they do report in their monthly reports then when they do have a customer, or their customer do have such a requirement. We have seen that happening, and we've got volume reports where this was done. So I'm not sure if I'm answering your question. Only one case, Sunrise Energy, because the other 2 facilities only the customers and the usage or the product there is only LPG. In terms of your comment about paragraph 24, we note that, and maybe it's the way we've worded it, but I think that it's a commercial thing. But I think the point we wanted to make is that we can enhance then to that, or if the members feel we should completely remove paragraph, we will take that guidance from you. But yeah, that's my response. I'm not sure if the team wants to add.
Thank you. Let me just take Madam Maseti and then Mr. Sibanda in that order, please.
Thank you, Chairperson. Chairperson, I've got 2 issues to raise. The first one relates to one of the grounds that were advanced by the applicant here, to state that the tank in question is not efficient. It means it's uneconomical in the sense that it will have significant financial implications, if I were to put them in my own words, as it will require extensive maintenance, and also will incur significant operational costs. So from that point of view, it is uneconomical and inefficient to operate and include it as part of the regulated assets for the license. So I would like to understand to what extent have we considered this aspect, or did we dismiss it on the basis of the legal argument, of which legal argument still also it seems to me that there were different views on it. So I just want to understand on that part, and why will the applicant anyway want to remove this? What does the applicant stand to gain? And from our side, what is it that we believe that it is significant? It will play a significant role in terms of maybe the security of supply or other reasons for us to make sure that it is still required to be part of the infrastructure for this licensing. So that's the first one, Chairperson. The second question that I would like to find out, and this is also indicated in paragraph 10 of the submission, it seems to me there were different views as to whether butane it falls within the definition of the petroleum, what is it? petroleum infrastructure, not products, petroleum product or an infrastructure in terms of our legislation. Now, can we be pointed to the definition that seems to be maybe the catch-all, one that we rely on for us to now say butane is a petroleum product? Can we at least be pointed to that? And this for me is important because it seems we are holding different views on this aspect. At least we should be in a position to point out the provision of the Act, which appears to take that into consideration. Thank you, Chairperson.
Thank you, Mr. Sibanda.
Thank you, Chair. Chairperson, I think from Mr. Untit's response, it might then assist us to then point out that there are other facility. Well, one other facility that is licensed to store butane. Although, as I indicated, I guess the main argument really is from a legal as well as technical points of view. Now, the point that I was making with respect to paragraph 24 is that we cannot argue the commercial aspect if the licensee comes to the regulator and says, I need to decommission this particular asset. I'm not sure whether we can say, look, we must continue operating this license. This facility, which sounds to be the case that we are trying to make in paragraph 24, unless we rephrase it, so that we don't come across as saying you must continue to operate because there are these benefits in the market. Because I guess the applicant is advancing a different view, a different argument as to why this particular facility should not be licensed or should be removed from licensed activities. So perhaps we should then rephrase that so that we don't argue on behalf of the applicant. Chair. Thank you.
Thank you very much, Mr. Sibanda. Maybe in the interest of time, let me just also talk to some of the issues. To say that I think Mr. Untit, Madam Bowen and the team, please just rephrase paragraph 24, because in essence, it's just because we talk to the issue of the interchangeability of the tank, such that it can still be used for propane. It can still be used for any combinations of propane and butane, to the extent that one looks at LPG as a combination of the two. And just you can talk to that, not as necessarily the reason why it should be as it is, but for information and for understanding, also taking due regard of the limited pieces of equipment or infrastructure that can be used to import product into the country. I think it's important to just rephrase it along those lines. And then when it comes to the issue of the commercial viability, I think they are at liberty to revoke if they feel a facility is not commercially or financially viable for them to proceed. There is a provision for revocation, but it falls under facilities that should be regulated in terms of the Petroleum Products Act. And I think in terms of the issue that was also raised from Madam Maseti's side, is that you've got an opposing view. In fact, the opposing view is opposing the view held by the applicant, in the sense that the issue should not be regulated. And in terms of when one looks at it, because already it's been outlined in terms of the technical as well as legal viewpoints. that it should remain regulated. I think paragraph 14 provides what a petroleum product mean, and in terms of that meaning, it then includes this petroleum product. Hence, to the extent that even lubricants, we regulate them based on this definition. So that is a catch-all definition that we have. There could be then further arguments in terms of explanation, because it becomes a combination, maybe with a stretch of maybe definition. One were to say that you could even look at it from a point of view of having different grades of petrol, or petrol being comprised of different blending elements. So it's a different blend, but it's still petrol. So you can have various blends between propane and butane, ranging from 0 to 100. In other words, that would still maybe still be considered as a petroleum product in terms of being able to fulfill the function of any of LPG that is maybe generally in the 60 to 60-40 or 70-30 combination in terms of propane and butane. Let me leave it at that, and then Tim, if you may just quickly then respond to any issues I would have left in terms of the tank not being efficient and your stance in this regard.
Thank you, Chair. We will enhance as guided, but maybe just to make it clear that the facility is not decommissioned. The tanks are not decommissioned. They already converted it to the use of butane. Because, and this speaks to the efficiency question from Ms. Masetti, it is true if it's not economically feasible, and to keep a cryogenic tank, this is very old technology. You need to run a compressor 24/7. You need to cool it down to almost sub-zero temperature. So it costs much more to operate than storing. But butane has got a low flash point, therefore you need less energy. So we will enhance the submission then also to address Ms. Masetti's concern about the economics. But I just wanted to make it clear. I've put in the chat box, there are 4 such tanks. They are not decommissioned. They will just be converted to, or has been converted to, butane storage. So there's no decommissioning happening. It's just, it's not used for LPG, but just for butane, because of the lower or the more efficient operation. So we'll enhance paragraph 40, and then Ms. Masetti, I think Mr. Mkhize already addressed it. Paragraph 13 and 14 is the basis, but in the cover submission, the actual definition as taken from the Act is stated. But it says any liquid petroleum fuel. There's no interpretation of being it automotive fuel, because they say it's used for lighter fuel. Heating fuels is also fuels. Propane can be automotive, but it can also be heating. So we will enhance as guided the relevant paragraphs. I trust I've sufficiently answered Ms. Masetti, but yes, it is less economic. It's got a higher operational cost for LPG than for butane, so it makes sense from an economics point of view to convert it, and then it will not be decommissioned. It stays in service just for a product which they argued then don't need to be licensed. Thank you, Chair.
Thank you. Members, if you are covered, we can then proceed to the recommendation. Thank you. I'm seeing a thumbs up from Madam Maseti. Thanks, Ms. Banda and Advocate Tole. The recommendation is to request the PPS to consider and recommend to the ER to not approve PTT's application for the amendment of its license issued for the operation of a petroleum storage facility in Richards Bay, seeking to remove a butane storage tank previously used for LPG storage from its license, and to approve the decision and reasons for decision document attached here to as Annexure 1, subject to the enhancement that have been put forth during this meeting. By show of hands, members, if you support the recommendation. Thank you, Madam Maseti, Advocate Tole, Mr. Sibanda, I also support. This then concludes item 5 and takes us to item 6, which is the updated frequently asked questions and the tariff methodology on the tariff methodology for the approval of tariffs for petroleum storage and loading facilities, version 5. Over to you, Madam Bogo.
Thank you, Chairperson. We have Mr. Gaba ready to introduce the submission on behalf of Ms. Yokwane. Over to you, Mr. Gaba.
Thank you very much, good morning to the members. The purpose of today's submission is for the PPS to consider and recommend to the energy regulator the approval of the updated frequently asked questions on the methodology, on the tariff methodology for the approval of the tariffs for petroleum storage and loading facilities, which is the version 5 of that tariff methodology. In 2019-20 financial year, NESA embarked on a process of reviewing its version 4 of the tariff methodology for the approval of loading and storage facilities, which was necessitated by a need to optimally advance the objects of the Act while addressing challenges encountered with versions 2 and 3 of the methodology. The version of the tariff methodology for petroleum storage and loading facilities was completed in the revision rather was completed in 2022 and was approved by the energy regulator on the 31st of March 2022. As part of the continuation of the revision of the methodology, the changes made during the review were thus incorporated as part of the FAQs. The FAQs for the storage and loading facilities were updated according to the revised and new components of the newly approved version 5 tariff methodology, and can be found in paragraph 11 of the submission, and as stated before, based on the approved methodology. The updated frequently asked questions are here to attest as Annexure A, where Annexure A1 contains the track changes of the FAQs, and Annexure A2 contains the clean version of the updated FAQs. With that said, it is recommended that the PPS consider and recommends that the energy regulator approve the updated FAQ on the tariff methodology for the approval of tariff petroleum, or for the approval of tariffs for the petroleum storage and loading facilities attached to here as Annexure A. Thank you very much, Chair.
Thank you. Members, any questions, comments, or guidance? By show of hands, please. Advocate Tole, then Mr. Sibanda.
Thank you, Chair. Chair, I do support. I do not have any issues with the submission, and I do support it. However, I just wanted to find out from the team, because in the past, what they would also do would be to produce a simplified manual for the contact center staff members to be able to use to answer some of the preliminary questions, and where the questions tends to be too technical, they will then be forwarded to the relevant technical people within the division. I just want to find out that is that still the intention in terms of doing that, to really assist in alleviating a lot of questions being directed to the technical people when some of those simple questions can be addressed through the personnel in the contact center. Thank you, Chairperson.
Thank you very much there, Madam CEO. Mr. Sibanda, over to you, sir.
Thank you, Chair. Just a question of clarity. Just one issue from my side regarding trade receivables and payables. On page 16 of 67, paragraphs 3.3 and 3.4 and 3.5. Actually 3, 4, and 3.5, I think, yeah. So we've got timeframes there for trade receivables as well as payables and operating cash. But what we say on paragraph 3.6 is that if licensees have proof that their actual values for the above benchmarks are higher, the higher values can be used. And my question really is, aren't these sort of like standard timelines from an accounting point of view? And if so, why would we want to give licensees some leeway? And higher timelines or values, are those not indicative of inefficiency in a way? And yeah, maybe if that can be clarified for me, to say why are we giving leeway to licensees if these are standard timelines, and increasing them, is that not indicative of inefficiency on the part of licensees? Thank you, Chair.
Thank you very much, Mr. Sibanda. I would just like to get from the team in terms of the line fill. I think you seem to be totally excluding it. I would just like to know if you don't see a need to maybe explicitly state that it is, if it is, then explicitly state that it is included under inventory. If you can just assist in that regard. And I'm not so sure when it comes to the liquidity premium, for example, wouldn't it help to still keep it and just indicate that it is zero, although this is not taken into account, instead of not having it appear, and then people ask if it is indeed considered. I just want to get the clarity. Over to you, Mr. Gab and the team.
Thank you very much, Chairperson. I will assist with the questions. So, CEO, we will develop that simplified manual for the contact center, and we'll update members in due course. I don't have dates as yet, but then we'll keep the committee updated on when it has been developed and shared with the contact center. And then coming to Mr. Sibanda's question, yes, we do note the possibility of inefficiencies also playing a role in increasing the number of days there. But then the assessment that we do, and also in checking the reasonability of days that would be above the benchmark there, also considers issues of inefficiencies, and where such are picked up, they are then not allowed. But then we wanted to open this for efficiently incurred costs and justifiable number of days that would be above the benchmark. So hence we had that statement there to also cater for instances where there are issues or considerations outside of the licensee's control. And then coming to Mr. Nkize's question regarding line fill. It is practically included under inventory, say, but then maybe we'll just indicate in the FAQ that a line fill is considered under inventory here. And then we do take guidance that we also indicate LP in the formula and then just indicate that it's at zero. Thank you, Chairperson.
Thank you. Members, if you are happy with the responses, we may then proceed to the recommendation, which is on trying to get to it on page 6 of 67. It is recommended that the Petroleum Pipeline Subcommittee considers and recommends to the energy regulator for approval of updated frequently asked questions on the tariff methodology for the approval of tariffs for petroleum storage and loading facilities attached here to as Annexure A, subject to the enhancement that have been put forth in the meeting. Members, by show of hands, if you support this recommendation. Thank you, Madam Massetti, Advocate Stole, Mr. Sibanda. I also support. This then concludes item 6, and we then proceed to item 7, which entails a decision and reasons for decision on the tariff application by Stormcrow 10cc and for its petroleum storage facility located in Boksburg, Gauteng Province for the period 1st March 2023 to 28 February 2026. It's a multi-year tariff. Is here for approval. Over to you, Madam Bogo and your team.
Thank you, Chair. Oh, I see Ms. Mafumane is not in the meeting. I'll just introduce the submission. Otherwise, we had Ms. Mafumane ready to, who was supposed to introduce the submission. We'll take this matter as read as well, Chair. And the purpose is to request the PPS to...
Madam Mafumane is here. Asipe.
Oh. Okay.
Asipe may come in, please.
Please come in, Ms. Mafumane. Thanks.
Take it as read and just talk to the key aspects of this submission, please. You are muted still. Okay, Madam Bogo, you may just proceed then.
All right, apologies for that.
Challenge. Please proceed.
Apologies for that, Chair. So the purpose is to request the PPS to approve the tariffs applied for by Stormco for its petroleum storage facility and for the periods 2023 up to 2026. The application was prepared based on the approved tariff methodology and the latest version. And the difference, we also analyzed the application and determined tariffs based on the methodology, and the minor differences identified with regards in the ARI due to the weighted average cost of capital. And we therefore, Chairperson, recommend that the PPS approves tariffs of 21.85 cents per litre for the 2023-24 financial year, 21.98 cents per litre for the 2024-25 financial year, and 22.12 cents per litre for the 2025-26 financial year. And these are tariffs that were applied for by Stormcrow for its storage facility. We also recommend that the PPS approves the decision and reasons for decision document, which we have attached here to as Annexure A. Thanks, Chair.
Thank you very much. I think Asipe fell off and then it's been, received back. But I think we'll just proceed. Another opportunity will come for her. So let's then, members, put forth our comments, questions, or guidance, if any. By show of hands, please. Okay, I don't see any hands. With that, we can then proceed to the Oh, here is Mr. Sibanda.
Okay.
Mr. Sibanda, over to you, sir.
Chairperson, just clarity from my side. With respect to the throughput volumes, I think to start off with, well, on the one hand, we are saying that there are no historical records for throughput volumes, which is a serious concern. But we also say, and that's on paragraph 25, Chair, on page 7 of 32, and that the licensee has been running very low volumes, but there's no indication of how low these have been. Yet, when it comes to the efficiency analysis, we then use the projected throughput volumes that are based on the operational capacity. Not too sure whether that is correct, Chair. And also the fact that we then determine the what is it, the stock 10, and it's not clear to me what that is based on, whether that is the actual stock 10 or projected or desired stock 10. If we don't have historical data, how then do we determine the actual stock 10? And is it correct then to determine your efficiencies or to do the efficiency analysis using a projected or a desired stock 10? So that whole volume analysis for me is a bit confusing and a bit convoluted, unless maybe it's just the way that I'm reading it, Chair, but it's not quite clear to me, especially when we then try to determine the efficiency issues when we don't have the actual volumes, or rather the historical volumes. Maybe if I can be clarified on how we took that approach. Thank you, Chair.
Thank you very much, Mr. Sibanda. Mlembogo, if you may please respond. Issue you've got a stock 10, but at the same time you're saying there is no historical data regarding volumes that have been processed in this facility. So what do you mean?
All right. So Chair, what is happening is that the facility was not operated by the current licensee previously, so they do not have historic actual throughput volumes. But then, in terms of their contractual arrangements in place, the licensee considered that though those volumes are very low and they would render their facility uncompetitive. So they wanted to have their facility attractive to possible storage users, right? So in determining this tariff, they adopted a situation where they are using capacity 10s. So the capacity 10s are indicated there. They're just confidential. I want to mention that. So what we were doing in terms of assessing efficiencies, we wanted to check reasonability of the capacity 10s that the licensee is considering. Hence, we looked for peers, and then we saw that this is still reasonable. So Chairperson will also see how we further clarify this in the submission, so that it is not confusing to readers. But that is what is happening. So we are not.
I think that if I can just come in, please. The thing that you need to be clear about is you can't be saying there is no historical data, and then at the same time, you are making a statement that says it's based on historical data. So be clear here. The stock turn indicated on paragraph 28, it is a projected one?
Yes, sir.
Okay, I think then clarify it from the point of view that we're talking about something that is being projected here, having looked at the potential and propensity of them to be able to get additional, to look at the current as well as potential clients or prospective clients. So indicate that because you seem to be saying something does not exist and then making a decision based on its existence. So be very clear that this is for the future. It's a forecast or estimation going forward. I think if you can correct it that way, it will be able to then address the concern raised by Mr. Sibanda. Mr. Sibanda, you covered.
Yes, Chairperson, I think we do need to make that qualification that we are using projected stock turns, and
Okay.
But I was just a bit concerned with the whole issue of how we are determining that the efficiency when we don't have historical data. Things, but I do get the explanation. I think we need to explain it further in the submission. Thank you, Chair.
Thank you, Mrs. Banda. With that enhancement, Madam Bogo, we'll then go to the recommendation that the Petroleum Pipeline Subcommittee approves the tariff of 21.85 cents per litre for the 2023-24 financial year, 21.98 cents per litre for the 2024-25 financial year, and 22.12 cents per litre for the 2025-26 financial year, as applied for by Stormcrow for its petrol storage facility for the period 1st March 2023 to 28 February 2026. And the PPS to also approve the decision and reasons for decision document attached here to as Annexure A. As already alluded to, this is subject to the enhancement put forth in the meeting. Members, by show of hands, if you support the recommendation. Thank you, Madam Maseti, Mr. Sibanda, Advocate Stole. I also support. This then concludes item 7. And then we proceed to item 8, which is a report on the preliminary findings of the investigation of the Petroleum Oil and Gas Corporation of South Africa, SOC Limited, Petro SA for short. Their complaint against Transnet National Ports Authority, TNPA, which is a division of Transnet SOC Limited in terms of Section 31 of the Petroleum Pipelines Act of 2003, Act number 60 of 2003. Over to you, Madam Bogo, and your team.
Thank you, Chair. On this one, we request members' indulgence as we may take more time than normal in introducing this. We had hoped that we'd have a workshop, but then we'll try and do everything we can within the short space of time we have here. And just to note that it was also a multi-departmental project. Hence, we need a bit of time in introducing it. I will hand over to Mr. Riba, who's going to start, followed by Mr. Ndlovu, then Mr. Untit, and Lars, if need be. Thanks, Chair.
Yeah, even then, I don't think that each and every line must be read. I think just to highlight issues. Yes, we could take a little bit of time, but just to highlight key aspects and what you have come to find out. Over to you.
Good morning. Thank you, Chair. Morning, members, morning, colleagues. The purpose of this submission is to request the PPS to approve the report on the preliminary findings of the investigation into this complaint lodged by Petro SA against TNPA in terms of Section 31, as well as these preliminary findings, and also that to approve that these findings be shared with the parties involved so that they can comment on this, thus allowing the energy regulator to make a final decision. In short, Petro SA submitted this complaint on the 8th of September 2022, and in December 2022, the PPS approved that we can proceed and investigate this as a complaint. And the complaint itself was shared with TNPA and Petroleum, the Ports Regulator of South Africa, to solicit their comments. That was in January 2023. And their responses were received in Feb and in April, and attached as Annexure 3 and 4. And in essence, in short, what Petro SA is all complaining about is that TNPA is not charging the tariff that was approved by NERSA in 2021, January, and also requests that this agreement that they entered into with the TNPA for the operation of the marine loading facility in Mossel Bay be declared null and void. Please note that this agreement was signed in 2010. That's 4 years after the NERSA was enacted and the Petroleum Pipelines Act was effected. Petro SA alleges that this contract is in contravention of Section 34. Actually, must be found null and void in terms of Section 34 of the Pipelines Act, and also states that in this agreement, it is required as Petro SA to pay for maintenance, operation costs, and all that sort. And according to Petro SA, those responsibilities lie with the licensee, which is TNPA. However, it has to be noted that the agreement was signed in terms of the Ports Act, which also has its own provisions, which amounts really to overlapping jurisdictions, as we know, and those conflicting issues. That said, I won't take long. The issue about the tariffs being higher than what the NERSA tariff is, I'll allow Mr. Ndlovu to unpack all that stuff and how these payments that Petro SA is alleging to be paying to TNPA are in contravention of the Pipelines Act, and on the other hand, are required in terms of the Ports Act. And we'll try to unpack that story and then present our preliminary findings based on the analysis of that. And in terms of the applicability of Section 34, Lars will assist on how NERSA handles that matters, such matters in terms of that. Thank you, Chair. And that said, Mr. Mikesi may proceed. Thank you.
Thank you, Mr. Liver. Good morning, members and colleagues. To address the relief sought, we assessed the fees provided in the agreement against the NERSA-approved tariff. The analysis is provided on from page 26 to 30 of 64. Chair, the fees payable to TNPA by PetroSA are provided in clause 5 of the agreement, and they relate to a rental fee, cargo dues, port dues, and marine fees. We note that the cargo dues, port dues, and marine fees are determined in accordance with the TNPA tariff booklet, which is approved by the port regulator. These fees, Chair, are revenue streams for TNPA for basic port infrastructure and operations, and these fees were not considered in the NELSA approved tariff. And we therefore regard them to relate more onto the basic port infrastructure and not the designated SPM and the CPM facilities licensed by NELSA. And then, Chair, there is also the rental fee under clause 5, which TNPA charges to PetroSA. This fee was included in the tariff application by TNPA. TNPA forgone the asset base multiplied by WACC and only included the PetroSA expenses, and this rental fee was part of the PetroSA expenses. In 2021, Chair, we did not allow this fee in the NELSA analysis as a rate of return investment was already catered for through the asset base multiplied by WACC. With the two methodologies applied, however, the tariff was still within approval range, hence it was approved. And then now, Chair, should we consider the NELSA tariff to be applicable to TNPA to charge PetroSA, this rental fee would be equivalent to the NELSA tariff. So then, Chair, we did an analysis of this rental fee compared to the NELSA tariff, but we had to adjust the NELSA tariff to exclude PetroSA expense as the current approved tariff considered TNPA and PetroSA as one, and the tariff was to be applicable to third parties. The analysis of the adjusted tariff when compared to the rental fee is provided on page 28 of 64, and the analysis shows that the rental fee is below the adjusted tariff. And then, Chair, lastly, part of the lease agreement, there is also a maintenance obligation for PetroSA to maintain the facility. And as the Act, the Petroleum Pipelines Act, does not acknowledge the operator, the license was issued to TNPA, and as per the conditions of the license, TNPA is expected to maintain the facility in a fully operational condition. Also based on this, TNPA provided, though, that it included the maintenance cost in the tariff application, which was approved, and PetroSA was expected to recoup this cost when charging a handling fee or a tariff to third parties. Chair, talking to the findings on page 34 of 64, the first finding would be that TNPA is within its mandate to charge the cargo dues, port dues, and marine fees. These fees, Chair, were not considered in the NELSA tariff determination, and they can coexist with the NELSA tariff. The second finding is that we note that there's concurrent jurisdiction with the application of the Ports Act and the Pipelines Act by TNPA, and thus this requires robust consultation with the regulatory bodies. The third one, Chair, is as mentioned that the Act does not acknowledge the operator, and thereby TNPA is required to maintain the licensed facility in a fully operational condition. Further engagements are required on this front. And then, Chair, lastly, we identified that we have experienced challenges with this exclusive right of use agreement as they are not in line with the objects of the Acts and do not promote competition and the open access or common carrier approach. This exclusivity right, though, was not sought by PetroSA, but however, in our analysis, we did regard that these exclusive rights of use agreements may not be in line with the objects of the Act. And then, Chair, I'm not sure if Mr. Untid or Mr. Mbeti would like to add. Thank you.
Maybe just one, there was a comment on the MOU and how that can be improved given these concurrent mandates. The MOU, as guided by LAS, is a framework. So in terms of what's currently in the amendment, in the MOU, it allows for us to do this. So we don't foresee any need for changing that. But again, the implementation of that and getting this engagements on this practical matters going is the key. Thank you, Chair.
Thank you. Mr. Mbetsi, anything to add quickly?
Thank you, Chairperson. I don't really have much to add. My colleagues have said enough already, unless there could be any other question which are legally related to this matter. Thank you.
Thank you. Mr. Riba, giving you the last opportunity, then we go to questions and comments as well as guidance from members.
Yeah, thank you, Chair. Apologies, something omitted to mention is that this lease agreement expires in March 2024, and Petro SA also has an opportunity there to renegotiate the terms of this contract with TNPA. That is, if they are interested to continue being the operator of this facility, or maybe walk away and have TNPA appoint a third party, independent third party to operate this facility, and then be the likes of Petro SA and the others in the Mosebel area to be third parties for this facility. Yeah, that's another part we unfortunately omitted to mention. Apologies for that. Thank you.
Thank you. I think another important aspect that you would not include in your presentation is that noting that these are two state-owned entities, one would have thought they would do better having one shareholder to deliberate on these issues and be able to find an amicable solution, such that we don't have to go through all of this. That even when NERSA came in, the NERSA was talking to them through lawyers also, which made life very difficult. They had a representative other than just themselves, and not necessarily being able to get things resolved. I mean, in the quickest possible manner. That is one. Two is that yes, this matter needs to be also flagged with the National Ports Authority, the ports regulator of South Africa, PRSA, in terms of, as we talk to the MOU. And lastly, this should get into the program of stakeholder engagement in terms of licensees being warned, if I may use that term, around the issue of the agencies that they use, because practically you do not expect a licensee per se to be the one that operates a facility in terms of the actual work being done, because you can outsource any function. So that when you outsource, you are still the one that is responsible. I think all those things need to be clarified. So there are no excuses. Like we hear someone saying, "I'm not so sure of what the volumes are or what is happening." So this is part and parcel of what should be in the agenda of stakeholder engagement, particularly when engaging with licensees and prospective licensees. With that, members, I'd just like to get questions and comments as well as guidance from your side. Over to you. By show of hands, please. Madam Massetti, you may come in, ma'am.
Thank you, Chairperson. Chairperson, I would like to just start with the process, because sometimes these things may raise challenges, not just from the point of view of our service standards, but also just in terms of our annual performance, in terms of how long we take, and also just at what process of the investigation procedure are we at this point, since these are preliminary findings. I'm asking this question because it has been a year now, Chairperson, and if you look generally in the APP, we take about 12 months within which to finalize investigations. So I just want to find out, in terms of process and in terms of the procedures, where are we in terms of the investigation now? Because a year has now passed, and therefore, so I will take it that when one starts an investigation, you initiate it and then you conclude in terms of your findings, right? Whether they're preliminary simply because of the way that we are structured, we need to now turn to the parties and inform them about the conclusion. Then we take it to the next step of how they are supposed to resolve these issues, or whether there's a non-compliance that has occurred. Rather than to again go back and investigate. So I would not envisage that once now an investigation has been done and then at least we've got findings, now you test the findings because you want to give the other party an opportunity to respond to the findings and see then what's going to happen. Are we at that stage of the process or not? So so that's the first thing, Chairperson, that we just need to clarify in terms of the preliminary findings, the way that are envisaged in the procedures or in the in the process. Then the second thing, Chairperson, I'm a bit not quite clear in terms of the service in question here. I hear the issue of not complying with the tariff, but what is the tariff that they're complaining about, the services between the two parties? I think it needs to also just be emphasized. It was not easy because one reads a lot of information here. So is it the issue of the loading facilities, operation of the loading facility? What exactly is the tariff related for the tariff related to the tariff that is being complained of, that it's not in line with NERSA? Is it the operation of the loading facility or any other facilities? Because part of this also talks about issue of maintenance, the operating expenses. What do they relate to? Do they relate to this operation of the licensed infrastructure being the loading facility or other facilities? And how much is being charged? Is that what we're concerned about here in terms of the product in question and then the cost for it or the service, the charge for the service, which is the tariff? I just want to understand. The second thing then, if that is clarified, at least I would like to understand whether there is an issue of duplication of cost here, given the fact that we are talking about the concurrent powers here that arise from the Ports Act as well as from the PPA. So they arise in terms of what specific regulated activity. In terms of the operation, I thought maybe these are complementary jurisdiction because from our side, we would license the operation of the loading facilities. Then the Ports Act would grant permits for the facilities that are or infrastructure that is in the ports. So I just want to understand exactly how does the concurrency arise here? Is it complementary jurisdiction or is it concurrency? Are we doing exactly the same on the same thing here? So that I can understand and also get clarity on this issue of sort of a duplication of costs, Chairperson. And then there are issues just that I just want to get clarity on, and they actually relate to the issue of the volume risk profile, the risk, I think it's the risk. The issue of there are three things. One is the volume risk sharing revenue, right? So what exactly are sort of I know that the rules that we have in terms of the volume risk. So how did it apply here? Why are we mentioning it here? Its significance here in the way that it impacts on this tariff that we that these parties are disputing here. Then also because we also talk about Transnet deferred tax here I don't know how it features. Yes, we're dealing with the TNPA here, but Transnet is a different arm. Yes, they are sort of sister companies, one being a regulated authority. So I just want to understand how does it feature the aspect of the deferment of the allowable revenue for Transnet? How does it feature here? Why must it come in here? And also these issues of the time value for money and all of that, how do they come in on this, Chair? If that can be clarified between these two parties. Thank you, Chair.
Thank you very much, Madam Massetti. Mr. Sibanda, sir?
Thank you, Chair. My questions okay, let me just ask them probably based on the flow of the submission, starting from page 6 on paragraph 6.7. Just clarity there, the last statement where we say only the energy regulator can rely on the applicability of section 34 of the Act and not Petro SA. What exactly do we mean by that? Are we saying that no other person can lodge a complaint regarding an alleged contravention of section 34, except the energy regulator initiating a complaint itself? It's not clear what we mean by that particular statement. If maybe that can be clarified. And then I think it will be important in our finding to then indicate exactly what we are saying with respect to the complaint, because the complaint is about the tariff that is being charged by TNPA, and that it is contrary to the NERSA approved tariff. So I think in our finding, we need to then respond to that particular issue directly as to whether we have made, whether there is evidence pointing to that. And whilst still on that issue, so we do indicate, for instance, on paragraph 6.24, that the rental fee is already catered for in the tariff application. Similarly, we also do indicate that maintenance costs are already included in the tariff decision. Now, what is not clear to me in our findings is whether we have evidence of double charging or double counting when it comes to the tariff, insofar as those two items are concerned, that is the rental fee as well as the maintenance costs. Did you find any evidence of double charging there by TNPA? And if so, I think it would be important to then pronounce on that issue. And then on page 35, paragraph G, so we make a finding that the exclusivity clause in the agreement contravenes section 4.1 of the Act, but then that section is probably more of an object of the Act, although it is couched in an objective manner to say the authority must promote competition in the petroleum pipelines industry. So what I was looking for really is a specific clause, or a specific section of the Act that has been that is allegedly contravened when it comes to the exclusivity clause of the agreement. For instance, clauses that talk to third-party access, perhaps, rather than relying on a general section of the Act that talks to the promotion of competition. Surely there must be a specific section that we think has been contravened by the exclusivity clause of the agreement. So maybe we need to then look carefully into that. Otherwise, it just becomes a general finding that says, you've contravened a section that talks to the promotion of competition. But how did that happen? And then in our conclusion, we say this complaint is a clear demonstration that some of the complaints lodged by stakeholders fall outside of the ambit of the mandate of the energy regulator. I don't know what we mean by that. Are we saying that this is an example of one of those complaints that fall outside of our mandate? Yet we are making findings that there could be contraventions of the Act. So it's not clear why we're making that particular statement, given the preceding section on the findings. And then we also talk to issues of concurrent jurisdiction, and that the MOU needs to be reviewed. But what aspects of the MOU need to be reviewed, and what is it during our investigation that we encountered that needs to be addressed through an amendment or through a review of the MOU? It's not clear, but we then make this statement that the MOU needs to be reviewed. So perhaps we need to be more specific and cite issues that we think need to be attended to in the MOU. Thank you, Chair.
Thank you very much, Mr. Subanda. If you may respond, Tim, I think it's very important, like, for example, the issue that you need to rephrase that portion that talks to that the investigation of matters falling outside of our jurisdiction. It's certain elements of the course that we look at that are not necessarily determined by us, which talks to the issue of complementary jurisdiction in terms of what then the post regulator of South Africa would I would say determine and then feed into this process. I think if we can assist as requested by members, Mr. Riva and the team, just to say this is what is in the tariff. And then there are these costs, like in my understanding, the issues of marine services, cargo dues, which fall outside of what is considered in the tariff, because of how they are structured. So one would go into the agreement knowing what the tariff is and be informed of what the other aspects are. Where I would compare it with maybe the price of fuel and then the maintenance of the car being separate, but all of this making up the cost of ownership, or I would say cost of running the car. So I think just make it very clear to members, assist in that regard, and the issues that you are bringing in, to say why bring them in. And of great importance is the issue of the timelines in terms of indicating where are we? When did we start to have an investigation? Because it starts when, even if we come up with preliminary findings as the process unfolds, just to say in the process, where are we? So that there is no argument at the end of the day, like what transpired in the last year to deal with it. So please just assist. Mrs. Band, I saw your hand was up. I don't know if you wanted to add something.
Yes, Chair. The response by the ports regulator, they appear to be saying, look, this is a matter for NERSA to deal with. Yet in our analysis, which I do agree with, there are certain elements that fall within the ports regulator's mandate. But they didn't seem to share this view that there are certain aspects that actually within the that fall within the Ports Act. So I don't know what our view is on that. Did we go back to them, or are we intending to go back to them? With our preliminary findings to say, look, we think that there are these aspects that fall within your jurisdiction, and then there are these aspects that fall within our jurisdiction. But it's just their response that I was a bit concerned with, that they didn't seem to want to deal with this, with any aspect of this particular matter. Thanks. Maybe the team can assist them. Thanks.
Thank you. If you may respond, please, and be very conscious of time.
Okay, thanks, Chair. Let me start with the process. Yeah, this has been a thorny one. It's how our APP is crafted, let's put it that way, such that we can start an investigation when we gather all the information required from all relevant parties. It's not really about the adequacy of the complaint submitted itself. And that part that I referred to, the gathering of information from the parties, comes after the committee has approved that we can proceed with this investigation. That was in December last year. And parties were given 30 days. Unfortunately, we were working on working days, which was supposed to end in Feb. But there was an issue with the ports regulator who were aggrieved about their involvement, why we're seeking this from them, and trying to establish why we're involving them in this matter. And we tried to hold meetings with them, and that eventually happened late in March, where we met with the ports regulator, and eventually they submitted on the 4th of April the comments on the 4th of April. So in a sense, one will argue that that is when we start to count the 12 months as provided in our APP. Therefore, meaning that the conclusion will be next year, April. That's when we should be concluding this. I know it aggrieves the complainant in terms of the duration, but unfortunately, that's how the internal process is like, and the procedure was drafted. And in the midst of that, we had to go back and forth to Petro SA in June again. That's another meeting that we had to struggle to get. And also with the TNPA, who we were communicating with via its lawyers, CMS. Those meetings were more to seek clarity on certain aspects of their responses in order to allow us to, or assist us to finalize this findings. But in the meantime, we were already assessing or analyzing the information gathered. Transnet responded on the 28th of February. We were analyzing that information. We also met other parties like AMSOL, who is the service provider for all these operations and maintenance, which is contracted to Petro SA, trying to gather their role in this whole issue. So to say we started an investigation on this date and put a peg on there is quite difficult, because we're already analyzing information as we're going, just to make sure that we're not wasting time. But there were challenges with what we had gathered already. But as far as where we are right now, we are at almost the final end of this investigation, and which is way before the target. That is, if we get approval by PPS today in terms of what we are requesting about the findings, approval of these findings. The issue about the Ms. Bassetti asked about what the complaint relates to. It relates to the loading facilities. TNPA owns the marine loading facilities in Mossel Bay, and they are their licensees there. And this whole 15-year contract that Petro SA is disputing is for the operation of that facility. And by the way, historically, that used to belong to Moss Gas, which is now part of Petro SA, and it was transferred to TNPA in yesteryears. But now TNPA is the owner and Petro SA is the operator.
Mr. Riba,
So
may you please,
to that,
Mr. Riba,
Yes,
Riba, may you please just go straight to the questions that have been posed and respond to them. Try to assist members to understand without really bringing in other issues that would kind of not assist in terms of the understanding, please.
All right, thanks. Apologies for that. I was just answering the question about what the complaint relates to. It's about the marine loading facility, its operation, and the costs related to that. That is the tariff being charged, maintenance costs, and operation costs that Petro SA is expected to pay. And Petro SA has complained that these are supposed to be paid by the licensee, which is Petro SA, TNPA. Then in terms of the other questions, I allow Mr. Meketi to come in. Thanks.
Thank you, Chair. I'll start with Ms. Masetti's question. In terms of the service, clear on the service in question and what the complaint is being about. So ma'am, here, Petro SA are just saying that there's this lease agreement, and then in this lease agreement, there are fees that they pay to TNPA. So they don't want to pay these fees, and they just want to pay the NELSA approved tariffs. And then we in our analysis, we saw that some of the fees are not within our mandate. So it's like a surcharge. It's an additional fee, and they are relating more onto the basic port infrastructure and not the regulated SPM or the CPM loading facilities. So we could not make too much of a pronouncement on those fees that are overcharged, or however, we just said they were not within our mandate. So we were then left with this rental fee and the maintenance cost, which more fits into our regulated activity. So with this rental fee, ma'am, TNPA provides that.
Sorry, Mr. Ndlovu, sorry to disturb. I think here the thing is that fees are determined external to NERSA, but they may be included by NERSA if it is possible to include them, or if there are no complications around include them. Otherwise, they remain a surcharge. Here you've got cargo dues, for example, port dues, and marine fees, right? which, as you rightly state under 6.1.1, I mean 6.11 or 6.11, that they were not considered in NERSA's approved tariffs. So they then stand as a surcharge determined elsewhere, right? But because they are of a nature that including them in the tariff will also be complicated because they depend on a lot of other factors which are more operational at a particular time. If a licensee or maybe let's say a client, if a client is well informed that there is a tariff and then there are these surcharges, if you look at them as surcharges, then we would not have this complaint. And if that is understood in that context, that is my understanding of this. I stand to be corrected on that. And that is how we should be communicating this, so it is clear. You may continue and address if maybe I'm only wrong in this regard.
Yes, Chair, we are in agreement. Maybe we can, in 10 pages due to file, maybe in the upcoming tariff application, we can consider what should be considered in the tariff so that it's also passed on or it's recouped by the licensee. But also, Chair, bear in mind now that, for instance, the cargo dues, Chair, the DMRE includes that fee into the BFP. So we must also look into that aspect of not maybe doing a double charge in that essence. But I do take notes that we can engage into the fees that were not in the tariff so that we include them and it's reflective of PetroSA fully recovering its cost, Chair.
Okay, no, I think when it comes to that, it's also important for us, because I took it, there was a question, sorry, let me step back. There was a question to say, are we going to then further engage with PRSA or in terms of their response? My understanding in this coming forward here, being presented, is that there's going to be subsequent engagements with PRSA as well as with DMRE and others, because we've already, there's a process of trying to find alignment and what we is part also of the defragmentation discussion document, to say we also use the same language, the same terminology in addressing things so that it's understood, because you may talk of cargo dues here, but they are not may not be the same what the department is looking at. So these are some part of the things that should be aligned. Here is just the difficulty of including these dues and fees, which now we're saying they are sitting as surcharges, and they must be understood from that point of view. And also, as I said earlier on, if we engage stakeholders, we need to engage them with the understanding that they've got a full picture as to what they are getting themselves into whenever they then use such facilities, to understand what actually the tariffs that we determine or approve entail. May you please then assist in that regard. You may respond further from your side, please. And let's conclude this matter.
Thank you, Chair. And the announcements are noted. And then, Chair, there's a section on checks. The comments relating to the acts, I'll leave to my less colleagues to assist. So yeah, it's this aspect of the double charge and the rental fee as we'll take the guidance as provided by you, Chair. I don't know if my other colleagues can come on the other matters relating to our mandate and concurrent jurisdictions.
If I may just, I did put in the chat box, we base it, the exclusivity concern, on section 21K, which basically says that any party can bring in a vessel, and we're having the same challenge in terms of other facility in this regard. So the berth the marine loading facilities is open to anybody, and that party will pay the cargo dues and the port fees to the TMPA. Then the operation of that and offloading the vessel, that's the NASA mandate. So in this way, currently nobody can bring in a vessel except, or they can bring in a vessel, but it can only be offloaded, coupled, handled, discharged by PetroSA. And that is, in our view, well, maybe I would say in my view, contrary to what Section 21K provides, but maybe Mr. Mbetsi can just clarify that. In terms of, just to be crystal clear, to Ms. Masetti's question, where we are at the point now where we will share it with all the parties that I think you mentioned, we'll test it with them to say this is what it, and then we'll just bring it back with any comments they've got to the committee to finalize the matter. So there's, in our view, nothing further to investigate. Is the assessment. I think, I'm not sure if we've covered everything, Mr. Mbetsi.
Thank you, Martin. Thank you, Chairperson. I would like to talk to Section 34, maybe trying to respond to Mr. Sibanda's query. Sometime during the investigation of this complaint, PetroSA and TNPA, we realized that a bone of contention is with regard to the contract signed between, it's a lease agreement signed between TNPA and PetroSA. And PetroSA seems to think that NESA has the power to nullify such an agreement. And when we went further with this one on Section 34, we realized that NESA does not have power to actually nullify any contract or any agreement. The power that it has is to approach the court and to have such contract nullified if and only if such contract is inconsistent with the spirit of the PPA, because PPA is the legislation that is administered by the energy regulator. So that is all really what we've been trying to say there, that we don't really have power as NESA to nullify the agreement, but we have power to approach the court and say, court, after our own investigation, we tend to think that this agreement that is not sitting properly for reasons that are given. That's all that we're trying to elaborate. And if I were to go further, Chairperson, on to address the issue of MOU. The MOU, this issue is important because if NESA is issuing or is granting the license of loading licenses, and Petro and TNPA or post regulator, they issue permits to offload. For us, we think that those two institutions should then talk to each other through the MOU, of course. Because if you recall, Chairperson, we went to court some time back because of the license that we've issued to Avidia to offload, and somehow we even mentioned as to where they should offloading, and that was tantamount to giving them a permit, and we did not have power to do that. Martin will recall that part. Then we are just emphasizing the importance of the MOU with this regard. Thank you, Chairperson.
Thanks. I think it's important to phrase things accordingly. You know what Mr. Sibanda was stating, in as far as I understand, is that there's a general provision that you must not discriminate. You must, but we need to quote, and there are objects of the act. We need not just talk to the objects. We must also go to the applicable section, and then in that section we then clearly talk to it. For example, if this is in the condition of the license, we can talk of Section 34, subsection 1, C, say, for example, to state that categorically. So let's make sure that we are able to articulate that. And then when you look, for example, at when you're talking of, we can make reference to the Section 21. and not just leave it without talking to specific sections that are being that are being contravened, or we are of the view that they are being contravened. So that is the main thing that I find on it. And for me, this is a matter of enhancement, going there and talk to the specific sections, and not only the what you call the objects. And two, I also note all the comments that have been made by Madam Massetti on the chat, because you will recall that this is one that was received after we had already indicated that we need to go back to the procedure in terms of dispute resolutions, dealing with complaints, the issues of mediation and arbitration, to refine that. I think it's going to be important to kind of to workshop this procedure, particularly noting that for a long time we have not had such cases at PPR, and therefore it is going to be important to workshop it, taking lessons also from all the regulatory divisions, so that there can be some level of refinement and better justification. I think a lot of work must also go in terms of the front end loading of this process. And lastly, I must say that in doing that, we also need to take due regard of information coming through, because I've observed the number of meetings that were as I was just being CC'd in the communication of the team engaging with the lawyers from TNP and them getting cancelled at the 11th hour. And those issues, they add into the delay in resolving matters. But I take due regard of all the comments that have been put forth by Madam Massetti, and we also we have to include that and as part of that workshop. But Madam Massetti, I saw your hand was up earlier on. If you may also chip in this regard, so we can move towards a conclusion. Thank you.
Yes, thank you, Chairperson. Chairperson, I think you've summarized the issues, but there is a bigger issue here, Chairperson. I think the issue, because from my observation, I think it is the third time now, and we take a lot of time of the subcommittee, especially when it comes to investigations, whether investigation of complaints. I think there's a need for capacity building on on how investigations are supposed to be done and what needs to be questioned, because it's one thing to keep on meeting, but you don't even know how to prove the allegations, what specific evidence and information is required, why do you want to see so and so, what kind of information, nature of information, and all of that. And I think also the steps that must be followed. If you get to this point, did you get this, did you not get that? I think there's a need for, I think when we were taken through by international experts on how to conduct investigations of this nature, you have to develop some steps, and there are specific questions that are asked in each step. So maybe there's a need for that in this case. And then what also assisted to complement that kind of training will be the template that will be designed. That template will then assist them to say the first step is this one, ask for this information, ask for that information. So I think there must be a template. There must also be some, the procedures that will also talk to fast track procedures. If you don't get this, you don't have jurisdiction, then the matter must not sit there. So in that screening, you must even establish issues of jurisdiction and what is this complaint about? Prospects of success. Is it something that we really need to have a full-scale investigation on? And I think here we take a lot of time. We can't on a complaint, because a complaint, all the information must come from the complainant. We can't take a year just to say, we're going all over, we're going to ask people, and then it has taken a year. On a complaint, it is just that in our acts, we don't have the statutory periods. But generally, in other legislation, you will even have statutory periods there. a 1 year. If you want to extend because you did not get it, then there must be a process. You must also consult the complainant. Reason being that the complainant could be suffering some harm as a result of the complaint itself or the conduct that the complainant is complaining about. Now you take 2 years, it means it's a prejudice to the complainant. Hence you will even have to conduct the complainant and ask for an extension of the investigation. But it can't be forever. It's not an initiated investigation from our side. We have to also get the right information. So the process is just also not on chairperson. In terms of efficiency, in terms of also thinking about the party that says, I'm suffering prejudice here, and I need you as an independent body that you come in here, assist me. Now it will take you 2 years to assist that complainant. Those are the things that we need to deal with, but also just to capacitate the staff that has to deal with investigations, chairperson, because I can see sometimes that maybe one does not know where to start and when to stop, and what kind of information that from the beginning, once you screened, this is what we'll need to do to establish this. If we can't get this, then there's no case. If we can get this, then there's a case. Thanks, Chairperson. But also, Chairperson, I think in this process, it cannot be that after preliminary, then they are saying they will come back here and bring comments. It can't be comments. It must be a closeout report. And that's how we should do, so that you sort out even the annual performance thing. There's a start of the investigation, and then you do your findings. After doing your findings, you then, because we've got also adjudicative powers, then you give the other party an opportunity to respond to the findings. On that part, it's something else. Once you have concluded the preliminary, then that's the end of the findings. That other part might now lead to what? To adjudication. And on adjudication, you can't still put it under an investigation process. Otherwise, it will prolong your period. So it can be a back and forth, and therefore try to separate the step where you're now getting into the aspect of Section 25 of non-compliance that may then lead to adjudication. It must be a separate step so that it doesn't interfere with the last step when you now have made some findings. And that's when your 12 months ends. Thank you, Chair.
Thank you. I think it is very important, the issues that have been raised. We talk to the process and procedure. And I then, members propose that this matter be workshop, the process itself, as I had alluded earlier on, and if need be, can also be done under the auspices of the Capacity Building Steering Committee. We also look at the issue of capacitation in terms of skills development, as well as capacity building with regard to such matters, because we're seeing more and more of this as also stakeholders become more informed of our work. I would then say that with subject to the enhancements that have been put forth, that the team need to enhance further, and with the timelines be very categorical regarding the timelines, where we stand, where we are. And I think that when we're talking of timelines, it's also important to be able to account for the time and not just put timelines and explain why certain delays, why there were certain delays in the process. So if you can then be able to do that, it would assist. I take it then, Madam Boko, as the acting EM, you will take up the matter of capacity building in conjunction with also the other EMs. Members, with your permission, may I then move to the recommendations part? As I said, the subject to the enhancement as put forth in this meeting is that the Petroleum Pipeline Subcommittee is requested to consider and approve the report on the preliminary findings of the investigation into the complaint that was lodged by PetroSA against TNPA in terms of Section 31 of the Petroleum Pipelines Act, report of which is attached as Annex 1. the preliminary findings and let the preliminary findings be shared with the parties involved in order to solicit their comments, which will assist the energy regulator in its final decision on the matter. By show of hands.
Chairperson, before we vote, I think 14.1B, it's just hanging. I was just going to propose that maybe we remove it and consider A and C, because preliminary findings are considered and are said to be considered and approved under H. Thanks.
Okay. There's a subset of A and B. Okay. Oh, A and C, sorry. With that amendment to the recommendation and the enhancement that should be effected, members by show of hand, if you support the recommendation. Thank you, Advocate Tole. Thank you, Mrs. Banda. Thank you, Madam Massetti. I also support. Please be very efficient and prompt in effecting all these recommendations and take this process forward to conclusion. Thank you. This then concludes the matter for item 8. We're moving to item 9, which is the discussion document on the Transnet tariff application for its facility. Over to you, Madam Bog.
Thank you, Chair. We'll take this submission as read. And
the pipeline system,
Yeah.
Continue.
Mr. Kaba will introduce the document. Thanks.
Thank you, Chair. Just as a reminder to the members stemming from the workshop that was held on the 6th of September, Transnet is applying for an allowable revenue of 8.2 billion, which is typically a decrease of 14.52 from the compared to the allowable revenue that was determined of 9.6 billion by the energy regulator in respect of 2023 and 2023-24 financial year. However, it should be noted that although the allowable revenue that was determined of 9.6 billion in respect of that financial year, NERSA deferred an amount of 2.8 billion in the form of a regulatory asset base, and that is stipulated in the 2023-24 reasons for decision. The deferment resulted in an allowable revenue of 6.8 and an effective allowable revenue of 6.8 billion being used to determine the tariffs for the 2023-24 financial year. And as such, the allowable revenue applied for is 20.87% higher than what was determined in that period in the previous determination. The allowable revenue applied translates to an increase of 25.60% increase in the Durban to El Road tariff, which is approximately 15.81 cents per liter, and subsequently in the fuel price. The reasons for the increase are contained in the submission under paragraph 6.4. In this instance, as part of the discussion document, the energy regulator had also conducted its own preliminary assessment of the application, and so far we have determined an allowable revenue of 8 billion, and which the main differences between what Transnet has applied for and what we have preliminarily assessed is due to the regulatory asset base, and NERSA. This was a result of NERSA having excluded the deferred revenue clawback from the 2020-21 financial year amounting to 1.1 billion, which is inclusive of the time value of money. The energy regulator is yet to make its decision on the treatment of this revenue. As a result, then we have decided to exclude it from the regulatory asset base. Other differences are caused by the OPEX elements, where in our assessment as the energy regulator, we have determined that Transnet has escalated its some of its elements by using an annual CPI, which is an actual inflation for the year as at 31st of March 2023. And NERSA had found it appropriate to use the forecasted CPI figure, which is at 31st of March 2024, rather. And then other differences that emanate from the calculation then translate to the tax calculation differences as well. In addition, NERSA is also is in the process of requesting additional information from Transnet, which may also affect the final calculation. And it is our view, further view actually, that the projection by Transnet of having volumes which are 1.86% lower than the previous period is not reasonable and cannot be justifiable for Transnet, as it is not in line with the positive projections for the fuel sales and economic performances. Therefore, NERSA suggests that a revision of the latest estimate of volumes of the volume throughput for the 2023-24 period by above a 6.25% is in order to revert to the initially projected volumes accepted in the 2023-24 application. So after taking into consideration comments by members in the workshop that was held on the 6th of September 2023, we are asking the PPS to note the discussion document on the Transnet tariff application, pipeline tariff application for the 2024-25 financial year, and also to approve the publication thereof as attached here to Annexure A. Thank you very much, members.
Thank you, Mr. Kaba. Members, any questions, comments, or guidance, please, by show of hands? Mr. Sibanda, over to you, sir.
Thank you, Chair. Chair, I'm fine with the discussion document. Just want to propose that we include a question on the intermixture refractionator plant that we are bringing back into the RAB. I think we can probably include it under the discussion of the RAB. That's the only point I wanted to raise. Thank you, Chair.
Thank you. Mr. Kaba?
Thank you very much, Chair. As we all know that the intermixture refractionator plant was included in this year's tariff application with the associated OPEX as well. So we will be including that as part of the discussion and the effects of it. As we had promised, I think it was a comment by the members in the workshop that we do include the effects or let me rather say the effects of the inclusion of the IRP in the RAB. So we'll be including that as guided by the members. Thank you, Chair.
Yeah, the issue is to include the question on the intermixture being included in the RAB. So just to that one enhancement. Are you okay with that? Will you do that?
Yes, Chair.
Thank you. This then concludes the guidance or questions and comments provided by members to the team, and takes us to the recommendation, which is for the PPS to note the discussion document on the Transnet SOC Limited Petroleum Pipeline System Tariff application for the 2024-25 financial year, and that the PPS approves the publication of the discussion document for public comment with confidential information withheld as attached hereto under Annexure A. By show of hands, members, if you support that. Thank you, Madam Massetti, Mr. Sibanda, Advocate Tole. I also support, subject to that one enhancement. This then concludes item 9 and takes us to item 10. I have since been advised by Mr. Chokwe that this item is more of a governance matter and that we deal therewith under governance. Members, if you don't object, may we then deal with it under governance matters and perhaps have it as following item 15, the current item 15. Thank you. I see a thumbs up from Madam Massetti. Thanks for that. Let's then proceed to item sorry, that was item 11. Sorry, that was item 11. But then we, under item 10, we said we're just going to have a discussion on it. Just quickly present it and take it as read, as it's a matter that is going to be then decided upon via a round robin, which is a decision and reasons for decision on the tariff application by Porter Plant P2I Ltd, trading as Porter Traders for its 3 petroleum storage facilities in Mpumalanga for the period 1st March 2023 to 28 February 2026. Sorry, that is subject to the pending license application to serve before the REC on the 9th of October 2023. Just quickly, if you can just talk to that and allow a discussion.
Thank you, Chair. The multi-year tariffs applied for by Porter are highlighted on pages 12 of the PPS cover submission and page 17 of the decision and reasons for decision document. The main difference in the tariffs calculation included the below: differences in the WACC values due to the different gearing ratios used, differences in the OPEX values due to the disallowance of non-regulated expense line items, and differences in the net working capital values due to differences in the trade receivable values. The other key issue to consider, Chair, is that the grammar and formatting errors noted will be fixed at the round robin stage. Thank you, Chair.
Thank you. Any issues, members, to guide and comment on, or questions that will then help in the round robin part of the work that the team needs to then provide as a submission to us? I see no hand raised. We will leave it at that. So we're looking forward to a round robin decision in this regard from our side. Members, just a show of hands to support that this be dealt with via round robin, having been presented to us now. Thank you, Madam Massetti. Thank you, Advocate Tole, and then Mr. Sibanda. I also support the round robining of this submission. We'll then go to item 12, which is the piloting of version 8 of the tariff methodology for petroleum pipeline facilities. Over to you, Madam Bog and the team.
Thanks, Chair. Mr. Kaba will introduce the document and for Ms. Yokwane.
Thank you, Chair. The revision of the revision of the tariff methodology for pipelines, Chair, facilities was conducted and completed during the 2022-23 financial year. And this was approved by the energy regulator on the 30th of March, 2023. The piloting of the methodology aims to prepare the industry for the implementation of the efficiency adjustment factor and volume rules, the possible removal of time value of money, as well as creation of regulatory asset liability, and not limited to the deferment of allowable revenue, which is among other new and revised components of the methodology. It will also contribute towards the development of a criteria or guidelines for the implementation of new elements, namely the removal of the time value of money, possible thereof, the creation of a regulatory asset as mentioned above, and etc. The results from this piloting will contribute towards the final version of the pipelines methodology and will also be incorporated into the final FAQs at the end of the 24-25 financial year. The energy regulator on March 2023 recommended that the piloting report be submitted to the PPS for noting at 6 monthly intervals, if I may put it that way. The report is attached here to in the submission as Annexure A, and the piloting was conducted on tariff applications that were set by NESA over the 2022-23 financial period, and which is outlined in paragraphs 5.4 to 5.8 of the cover submission, as well as attached to as the Annexure A attached here too. A summary, just a brief summary of the results from the piloting so far show that version 8 of the tariff methodology yields a relatively efficient tariffs compared to those determined using the previous version 7. The key determinants of the results include the removal of the liquidity premium from the risk adjustment factors of the cost of equity, as well as the conversion of the tax approach from a notional to a flow-through tax approach. However, for the Transnet pipelines piloting, the removal of the time value of money and the deferment of allowable revenue, as well as the creation of a regulatory asset were also piloted, and they played a key role in the reduction of those tariffs. The second installment of the report on the piloting of version 8 of the tariff methodology for the setting of these tariffs for pipeline facilities is expected to be submitted for noting by PPS on February, at the PPS of February 2024. And the energy regulator of March 2024. Thereafter, it is envisaged that the approved version 8 of the tariff methodology for the setting of tariffs will then be published and implemented. With that said, it is recommended that the PPS consider and note the first biannual report on the interpiloting of version 8 of the tariff methodology for petroleum pipelines facilities. Thank you very much, Chair.
Thank you, Mr. Kaba. Just to members, the issue of aggressively engaging licensees and prospective licensees on this has been raised with the team, and it will be important, team, that when you come for the last submission, we have dealt with that aspect thoroughly, because it is going to be important for the licensees and prospective licensees to have and better understanding of this, so that when when it comes to the transitioning is short, as well as that there is a smooth implementation of this. I think the same applies to the next presentation that deals with the transitioning of the new tariff methodology for loading and storage facilities. Having said that, members, you may please raise your hands if you've got any comments, questions, or guidance to put forward to the team. Madam Massetti, over to you, ma'am.
Thank you, Chairperson. I'll be quick. I just want to find out about the duration of this piloting exercise. Number one. Number two, just to check if we are already implementing and calculating the tariffs for these specific licensees using version 8. Are we already doing that in the same way that we have done the RRMs, or are we doing it differently? Just want to check that. And then thirdly, how did we select these specific licenses compared to the others that are there? Did we look at the capacity? What exactly did we look at in identifying these specific ones? That is the third thing. And then I think the fourth thing that I want to understand, I see when we deal with the Transnet matter, we, especially on the issue of the tax there, I think in the submission that we considered the notional tax as opposed to the post-tax option. Is there a reason for that? Why didn't we use the post-tax, the flow-through tax there? And maybe it would have reduced also the amount. So we need to just look at that, unless then the methodology also allows for an adjustment. And sometimes I don't get to see that adjustment when you deal with the clawback, so that one can be able to understand how some of these sort of projected figures have been dealt with, because sometimes the clawback there is largely influenced by the volumes that were actually achieved. So if that can also just be clarified, how did we deal with it? Because I see it is still there. Now, the issue of I know that the deferment tax has been removed, but it seems now we're still on the deferment of the allowable revenue there. The last point, Chairperson, is on the volume risk sharing mechanism. I'm not sure where we are in terms of that. Remember that the project was completed more than a year ago. And it was for a reason that we wanted to come up with that volume risk sharing approach. I just want to find out, at what point are we going to be ready to pilot that aspect and also identify information that will be required, even if we can, some of the information then from our side, we collect it. But just in terms of the burden on the parties, is there any sort of specific challenge in us implementing that aspect of the volume risk sharing? Because it has been there. I don't know what exactly now is the key challenge for us to implement it. If I can be enlightened on that as well, Chair. Thank you very much.
Thank you very much, Madam Massetti. Over to you, just to respond.
Okay. Thank you, Chairperson. With regards to the duration of the piloting exercise, it was approved by the energy regulator to be 12 months, ending March 2024. So that's what it is, 12 months, ending March 2024. Yes, Ms. Massetti, we are simulating the effect on the tariffs. We did also sort of calculate the tariffs based on version 8 of the methodology to also look at how the effect would be on the tariffs. That was also an important element for piloting the methodology internally before publication. And in the licenses, we piloted the methodology on all pipeline licenses. So the few licenses you see there all the pipeline tariffs determined over the period from April this year to date. So we'll also be considering further pipeline tariffs that are applied for in the period. So what you see in the Transnet application now, especially, is based on version 7 of the methodology. Hence, we're still using notional tax and not the flow-through tax. But then once the methodology is published and finally approved, we'll move to the next version of the methodology. And with regards to the volume sharing mechanism, we concluded consultation in August this year. So we are set to still bring the final decision to PPS, then the energy regulator. There are challenges we are trying to iron out, especially with our research department, and we are still conducting workshops. We have conducted workshops internally with also our FTRM, and we'll bring the final decision on this in due course, and it will then be implemented. Otherwise, the decision has not yet been taken. What we had brought to PPS was a consultation document on this. It is a bit challenging because it's a first of its kind for us as NERSA. Hence, it's taking much longer than initially anticipated. Thank you, Chairperson.
Thank you. I think it's also important to note that with the Transnet pipeline, because you still look at the version 7, you're still using version 7, but like we have done with all the other applications, where you look at version 7 and then you then provide an assessment in terms of the pilot to say with regard to what would have transpired had this been version 8, this would have been the tariff. I think that is what we keep doing as we are piloting. Because this is the essence of piloting. So that will also have to be provided, even for the Transnet pipeline system. Are we good on that?
Yes, Chair, we are doing that concurrently.
Yes, thank you then. Madam Maseti, are your issues addressed, ma'am?
Yes, Chairperson, thank you.
Thank you very much. This then takes us to the recommendation, which is on page 10 of 24. It is recommended that the Petroleum Pipeline Subcommittee notes the first biannual report on the internal piloting of version 8 of the tariff methodology for petroleum pipeline facilities. By show of hands, members, if you support this recommendation. Thank you very much, Mrs. Banda, Madam Maseti, Advocate Stole. This recommendation is supported. So we proceed then to item 13. Item 13 deals with the biannual report on the transitioning of the efficiency adjustment factor and volume rules element of the tariff methodology for petroleum storage and loading facilities, version 5. This methodology was approved, and then there was piloting, but then there are certain aspects that were said that we need to phase them in slowly in terms of the transition, which is the efficiency adjustment factor and volume rules for 12 months, ending on the 31st of March 2023. Again, as I said earlier on, the issue of aggressively engaging with licensees and prospective licensees is key here. Over to you, Madam Bogo and your team.
Thank you, Chairperson. The purpose of this submission is to Sorry, the purpose of this submission is to request the PPS to note the biannual report on the transition of the efficiency adjustment factor and volume rules elements of the tariff methodology for petroleum storage and loading facilities Vision 5. Just to take you back, as Mr. Mkhize has already mentioned, this transition process was approved by the ER on the 31st March 2022 for the period of 12 months in order to prepare the industry for the implementation of Version 5 tariff methodology. The transition process was processed through a number of tariff applications in order to ensure diligent implementation of the ER resolution, and the report on transition of Version 5 was tabled at the PPS meeting of 8 February 2023 for noting. The PPS members requested that the transition period be extended. However, the extension be limited to the efficiency adjustment factor and volume rules, considering that the challenges observed were limited to these elements. The PPS further requested that the team report to the PPS biannually on the progress. Just to give the update of the previous transitioning submission, in the previous transitioning submission noted by the PPS meeting of 8 February 2023, the NERSA set volume targets for the licensee listed on page 4 from paragraph 11.1 to paragraph 11.4. And the results show that there is a significant degree of inefficiency among the licensees that had efficiency adjustment through volume rules targets set in the previous financial year period. Of the 5 licensees that were required to achieve the volume target set by NERSA, only one showed a slight increase in volume from the previous period, while the other 4 presented volume declines. None of the 5 licensees met the volume target set by NERSA, and therefore they do not qualify to apply for revenue clawbacks in their next tariff application. And we continued with the transitioning. Paragraph 15 lists 9 tariff applications considered by PPS in the first and second quarters of the 2023-24, which were used to assess the impact of Version 5 on the efficiency adjustment factor and volume rules. And the assessment of the efficiency adjustment factor and volume rules is summarized in paragraph 16 to paragraph 35. It is therefore recommended that the PPS notes the biannual report on the transitioning of efficiency adjustment factor and volume rules of the tariff methodology for petroleum storage and loading facilities Version 5. Thank you.
Thank you very much, Madam Sibake. Any questions, comments, or guidance, members? By show of hands, please. I don't see any hands. And then with no hands, I'll just like them to move towards the recommendation, which is that the PPS notes the biannual report on the transitioning of efficiency adjustment factor and volume rules of the tariff methodology for petroleum storage and loading facilities Version 5. By show of hands, members, if you support this recommendation. Thank you very much, Madam Massetti. Advocate Tole, Mr. Sibanda, I also support. This then concludes item 13, and it also concludes the open section of this meeting of today. I would like to take this opportunity to thank all members, management and staff in this meeting, as well as members of the public that take interest in the work of NERSA with regard to the Petroleum Pipeline Subcommittee, and wish them a productive day further. The meeting then in the open session is adjourned. Thank you.